Young Scholar Series is an ad hoc series that started a few weeks ago, a few months ago. There were a series of young scholars from Japan who spoke on various topics related to Japan. Today we have a PhD student, Loja from the Philippines, who's doing a PhD here under the supervision of Simon Young. She is going to speak on the territorial dispute between China and Japan over Diaoyu, Senkaku Islands. She's going to speak about some of the research that she's been doing, and that will form the basis of, or has formed the basis of, an article that will be forthcoming at one of her publications. So that look forward to hearing what she has to say. Melissa.
Thank you very much, Professor. Yes. Good afternoon, everyone.
Yes.
This afternoon's presentation is based on an article which is forthcoming in European Journal of International Law.
Perhaps you use the microphones.
Is it fine now? The presentation is organized into 4 parts. The first part is a short background to the dispute. The second and third parts are my alternative approach and findings, and the last part is conclusion, after which we shall have our discussion. Part 1 is a review of the basic concept of territorial title and the traditional approach which is applied by most authors to address the dispute over the islands. Territorial title is basically the best right of a state to take possession of a defined space to the exclusion of other states. Like other rights, it should be based on certain set of facts and or certain set of evidence which some law recognizes as constitutive of title. So you have 4 elements: defined space, fact, evidence, and law. Example of a fact would be the cession of the Philippine Islands to the US. Example of an evidence would be the instrument of cession recording the act of cession by Spain to the US. The more controversial element is the element of law. In international law, it's commonly or basically known as any rule of conduct which is accepted by the parties based on their agreement or on their consensus or their acquiescence. Right? So, with respect to the Senkaku Islands, there is no dispute among authors who apply the traditional approach that the islands constitute a defined space. It's not a submerged reef, it's not a low-tide elevation. Therefore, as a defined space, it is susceptible to territorial acquisition. There's also agreement that Japan is currently in possession, effective possession of the islands, but that it was China which was first to cite and name the islands. There's more or less some agreement on that. The dispute revolves around the question of whether China or Japan took physical occupation or inhabitation of the particular disputed islands, or that they incorporated the particular disputed islands into any of its provinces or exercised actual jurisdiction over the particular disputed islands. I emphasize the word particular disputed islands because most of the arguments relate to Ryukyu, but not to the particular disputed features. Right. They also revolve around the question of what is the source, what is the law which could give rise to title based on evidence of siting or occupation or evidence of possession. Those who favor the position of Japan would cite the San Francisco Peace Treaty or the Okinawa Reversion Treaty. The Peace Treaty granted administration over the islands in favor of America. The Reversion Treaty relinquished administration of the islands in favor of Japan. Right. Those who favor the position of China rely mostly on historic title and ancient maps. Historic title is basically title which is based on common knowledge and reputation that a particular state has been in possession of the islands since time immemorial, and that there's no evidence of a contrary state of affairs. Okay. Those who rely on ancient maps usually cite maps which depict the islands as part of China or part of Japan. Okay. I departed from the traditional approach and used an alternative approach for the following reasons. First, China, communist and nationalist governments were deliberately excluded from signing the peace treaty. This document is known as the Morrison-Dulles deal, where the US and the UK agreed that China would not be included in the signing of the peace treaty. Japan also deliberately excluded China from signing the peace treaty, although eventually Japan signed the peace treaty with the nationalist government and with the communist government, a French treaty in the 1970s. But the more important reason why I departed from the traditional approach is this 2014 study, where we found 9 cases in which the parties invoked historic title or ancient maps. If you look at the table, you will see that out of the 9 cases, only in 2 cases was historic title found to exist. And what is more important is that the finding of historic title is based on the following evidence. 1, evidence of the existence of a central authority. The original title holder has to be the central authority. Second, evidence that that title holder exercised sovereignty over the disputed territory. In all the 7 other cases where there was no finding of historic title, or there was a claim for historic title but this was found unsuccessful, the evidence relied upon by the parties claiming it were, first, allegiance of a tribal, cultural, or religious settler group in favor of the claimant, and that settler may have used the island for economic reasons. 2, discovery, such as in the case of Island of Palms between the US and the Netherlands, contiguity, and most especially ancient maps. In all these cases, the claims failed principally because there was no evidence of actual exercise of sovereignty by a central authority. On the question of ancient maps, the tribunals have been very consistent. They have consistently held that maps are neither source nor evidence of title to territory. Okay. The only time that maps can be evidence or source of title would be when the map is annexed to a treaty and or the map is accepted by the parties as the authoritative interpretation of their boundary. Okay. The only possible function of a map is as extrinsic or corroborative evidence of a title already existing on another basis, okay? Provided that the map has technical reliability and neutrality in terms of source in relation to the parties or the dispute. Okay. Now, with respect to the Senkakus, the only map which I found to be of value is the map which is referred to in Article 3 of the treaty. Article 3 says that there is supposed to be a map annexed to the treaty. The trouble is, according to authorities such as Hertzlet, no map was actually attached to the treaty. Moreover, in the subsequent convention on the retrocession of Fengtian or Liaotong, Article 3 of the Treaty of Shimonoseki was suppressed, and presumably along with it, the next map. Okay. To summarize the first part, we said the title has to have the elements of defined space, fact, evidence, and the law giving rise to it. Controversy over the disputed islands revolves around the law, which should be applied to confer title to either Japan or China. And I said that I found the use of historic title, ancient maps, and treaty rather severely limited. which is why I used an alternative approach based on status quo post bellum. I shall explain this in part 2 by giving an overview of the approach I used and the concept of status quo post bellum. In my research, I used primarily archival records, which are considered or recognized as evidence of state practice. That's how I distinguished my paper from other authors. Second, I subjected the records to 3 levels of analysis. First, I tried to identify consensus of the parties on the status of the islands during the period 1945 to 1952. 45 being the surrender, 52 being the effectivity of the treaty. Then I tested the consensus against any possible prior existing title, which in Eritrea versus Yemen must be clear and convincing. Then I tested the consensus against the conduct of the parties between 1952 and 1970, 1970 being the critical date. So I based my approach on status quo post bellum, therefore I need to explain what it is and whether it is a tool for resolving territorial disputes. Status quo post bellum is a situation of a territory or the position of parties at the end of a conflict. That situation or position is deemed as the legitimate state of affairs from which they are to refer when conducting their relations in the future. The basis, therefore, of accepting the state, situation, or position as a starting point is obviously tacit recognition, or mere consensus. Not consent, but merely tacit recognition or consensus. So that would be the consensual element of territorial title, right? So the question I need to pursue was whether tacit recognition could give rise to territorial rights. There are jurists who said that yes. Vattel, for instance, says that since there is no third state or third party which can decide for the 2 disputants on which one of them would have possession of territory, then their state of affairs at the end of their conflict has to be accepted as the valid starting point. Philippson, on the other hand, says that this presumption arises in favor for the security and protection of third states or third parties, because they cannot presume to deal with the territory differently from the objective fact that one state is in possession and the other is not at the end of the conflict. I also found references which mention treaties where the concept of status quo and tacit recognition is incorporated as a provision. And these are the treaties mentioned. Finally, I found the international tribunals applying the concept of status quo. For instance, they use the word general opinion for convergent positions, which is equivalent to almost tacit recognition. But most importantly, it is used in cases of utepas seditis iuris. I forgot to mention that utepas seditis iuris is one form of status quo post bellum, where the territorial boundaries, the administrative boundaries established by the colonial power, is deemed to be the international boundaries of newly independent states after the end, at the end of wars of independence. So here, there's almost frequent use of the word tacit recognition. This case where status quo post bellum was applied is the most relevant to the dispute over the Senkakus. In this case, Yemen and Eritrea disputed various islands in the Red Sea. The particular island where status quo post bellum was applied was the Mohabakas. Yemen's claim was based on historic title established by the Imam since ancient times, while Eritrea's claim was based on a peace treaty called the Lausanne Treaty between the Ottoman Empire and the allied British Empire. Okay. Yemen disputed the application of the peace treaty on the ground, like China in relation to the San Francisco Peace Treaty, on the ground that the Lausanne Treaty was not a signatory to it, and therefore the treaty should not apply to its claims to the Mohabbakas. Okay. The court ruled in favor of Eritrea and said that yes, Yemen did not sign the treaty. No, Yemen does not need to sign the treaty in order for the treaty to apply to the Mohabbakas, for the simple reason that Yemen had no interest in the island at the end of the war between the Ottoman Empire and the British Empire. At that point, at the end of the war, it was the Ottoman Empire which was sovereign over the islands, and not Yemen having any interest to the islands. Whatever historic title Yemen may have acquired, or its original title holder may have acquired, was deemed aborted by the act of conquest of the islands by the Ottoman. At that time, conquest was a valid mode of territorial acquisition. Note that in that case, the court did not simply rely on the concept of tacit recognition to grant title. It also required evidence that whatever title may have arisen from based on tacit recognition was tested against any prior existing title. And it found no clear and convincing title existing prior to the war, to the end of the war. On the part of Yemen, its historic title was deemed awarded when the Ottoman Empire conquered the islands in the Red Sea. Also, it tested the status quo against the subsequent conduct of the parties, and it found that Yemen did not conduct itself as though the islands were still under its sovereignty at that time. Right. To summarize part 2, here I explain why I use an alternative approach and how I justified the use of status quo post bellum. Right. So status quo post bellum is basically reliant on the consensual element of tacit recognition. In part 3, I discuss my findings after I applied the alternative approach. Okay. First, I discuss my findings on the applicability of the approach in relation to the Senkaku Islands in particular. Then I discuss my findings on the status quo within the period 45 and 52, and how I tested it against any prior existing title before 1945 and the subsequent conduct of the parties after 1952 up to the critical date of 70. To justify the application of the approach, I looked for conduct of China, Japan, and the Allied powers where they made use of the concept of status quo. This is an example of the conduct of China and Japan in relation to the Shimonoseki Treaty negotiation. Here it is apparent that China made use of the concept of status quo. In these negotiations, the Venerable Viceroy Li was representing China. Japan had demanded the cession of Formosa and Pescadores, and the Viceroy objected on the ground that Japan at the time of negotiation, or at the end of their war, Japan was not in possession, or there were no troops within Formosa and Pescadores. And the Viceroy said that under Western principles of international law, Japan is not in the position to demand the cession of these islands. Okay, this is just an example of conduct applying the concept. But with respect to the islands in particular, to the disputed islands, I found three important instruments where the concept of status quo was applied. In the Cairo Declaration, there was a decision among the three signatories, China, US, UK, to treat the territory after, let us say, after the surrender of Japan. They agreed that, number one, there should not be any aggrandizement among them. The concept of non-aggrandizement would apply to the territory of Japan. So they covet no gain at all. So it would be important then to define what they meant by no territorial acquisition of Japanese areas. Okay. Second, they agreed that all territories which Japan stole from China needs to be restored to China. And this includes Formosa and Pescadores. In this document, the Potsdam Declaration, they further defined what they meant by territory of Japan which shall not be acquired by any of them. Okay. And here they said that Japan's sovereignty shall be limited to 4 main islands. But then they added a clause which says, and such minor islands as the allies shall determine. All right? So the concept of aggrandizement will apply to the 4 main islands and minor islands, whereas those stolen by Japan will be restored to China. Therefore, and here in the instrument of surrender, Japan accepted the terms of the Cairo Declaration and the Potsdam Declaration. Okay? Therefore, you have 3 categories of territory which should define the status quo at the end of the war. Category 1 would be the main islands of Japan, to which Japan's sovereignty will still apply. Category 2 would be minor islands, to which Japanese sovereignty could still apply depending on the decision of the Allied powers. And category 3, Formosa and other stolen territories. Okay. So my findings would then be limited to the status quo 1945-1952, which has 3 aspects. First, on the category to which the islands belong. Second, which state, which claimant, which state had any interest in the islands. And third, which state had any claim to it, official claim to it. Okay. I based my findings on consensus as to the category of the islands on the following documents. Under this General Order Number 1, it is clear that the intention of the parties was to make China occupy those territories which are to be restored to it, such as Formosa, whereas the U.S. shall occupy those territories considered minor islands whose fate shall be determined by the Allied powers. Okay. So I needed to find definition by China of what it meant by Formosa, which it occupied. And then I found this yearbook. It has to be emphasized that the yearbook, the international yearbook, is evidence of state practice. I found this yearbook where China defined Formosa as situated between 22 degrees north and 25 degrees north. Right? The problem is the disputed islands is situated at 25 degrees, 45 minutes north, 123 degrees and 30 minutes east. So based on this document, I come to the conclusion that from the point of view, or from the view of China, the Formosa which it occupied did not encompass the disputed islands. Otherwise, it would not have defined Formosa in this manner. I also looked at the constitutions, and I traced the constitutions all the way back to 1919, going to 1946. The Constitution made reference to various islands, but not to Senkaku at all. It made reference to Formosa, and this is how it defined Formosa, as 22 degrees north and 25 degrees north. Right? Then I looked at the view of the US. How did it regard the term minor islands? How did it define minor islands? This is an ordinance issued by the Ryukyu military government, and it defined its jurisdiction according to these boundaries. The Senkaku falls within the boundaries called Ryukyu. I looked for protests from either China or any other state, but there was no protest against this public ordinance. Okay, and then they looked at the conduct of Japan. How did it view the minor islands whose sovereignty might be returned to Japan upon the decision of the Allied powers? There were many drafts of the peace treaty from 1947 going to 1951, but only 3 were important in the sense that these 3 drafts were circulated and various governments commented on the drafts. The first draft is the March 1951 draft coming from the US, and the other is the joint US-UK draft. In all of these drafts, they use the word ryukyu. Japan is given a copy of the draft, and it filed a comment to the draft where it asked that the word ryukyu be replaced with the word nansei, for the reason that Nansei Islands would encompass all islands between Kyushu and Formosa. Okay, this is April 4. This is in reaction to the March 3 draft. Okay. By July, Japan reiterated its comment by asking again that Nansei Islands be used instead of Ryukyu. Okay. Simply for the reason that Nansei includes all islands south of 29 degrees north latitude, while Ryukyu does not. The reaction of the US was this. According to the State Department, in their mind, Ryukyu already includes Sento Islands, which is another word for Senkaku. Although it agreed that yes, the use of Nansei Islands might be historically correct because it would encompass, it would be more extensive than the word Ryukyu. And so the State Department issued instructions to its embassies to substitute the term Ryukyu with the word Nansei in the draft, which are to be circulated to the governments preparatory to the signing of the peace treaty. All right? And eventually, this was the term used in Article 3 of the peace treaty. Okay. So if the dispute is over the term Nansei Shoto, if you look at the historical record of the use of the term, you would know the intentions of the parties, why they used the term Nansei instead of Ryukyu. Okay? Now, it's important for me to emphasize that in using these documents, I'm not supporting the view that the claim should be resolved on the basis of the treaties. I am using these documents to indicate the conduct of the parties, whether they came to a consensus on the extent of the word minor islands. Okay? So, based on these documents, I come to the conclusion that the disputed islands fall under Category 2 rather than Category 3. Right? Okay. Then I looked at their consensus on which state had an existing interest in the islands. Again, I looked at the negotiations on the peace treaty for their conduct and their views. And I found that in all the drafts, even all the way back to 1947, there was always the need for Japanese concurrence on the disposition of the islands. Okay? Therefore, this is a clear indication that they recognize the remaining interests of Japan over the islands. Okay. As to the consensus on which state had any remaining claim on the islands, I found that in 1943, there was a meeting between Roosevelt and Chiang Kai-shek. And they were discussing, if you look at the record, this is a transcript. First, they were discussing the islands stolen, which were to be restored to Japan. Okay. So the first part of the discussion was on the islands to be restored to Japan. Right? Then Roosevelt directly asked Chiang Kai-shek whether it was claiming the Ryukyus. Right? And the response of Chiang Kai-shek was it was willing to have it jointly occupied between China and Japan. From this exchange, it is apparent that for China itself, the Ryukyus would not fall under minor islands, category 2. Right? I mean, sorry, it would not fall under category 3 Formosa. I also looked at the comments of the various states on the provision itself, and I found that except for Canada and New Zealand, which sought the cession of Ryukyu to the US, all the other states recognized that it is possible for US to have administration of the islands, but eventually the islands have to be returned to Japan. More importantly, I found this statement by Foreign Minister Chow En-lai saying that US occupation must end within 1 year from the signing of the peace treaty, meaning US must withdraw from Japan within 1 year, and that Japanese territory must be restored to Japan. More or less, there is consensus, therefore, that number one, Japan had an interest, retained its interest on the disputed islands, and number two, China was not a claimant to the islands. Okay, so I tested the consensus against I tested the consensus against any prior existing title, which has to be clear and convincing. As I mentioned, using these findings from the 9 cases, the claims to historic title would not be successful. Basically, there is no evidence of actual occupation or inhabitation of the particular disputed islands. Number 2, the claim to administration through Ryukyu is apparent from the position of China, that there is no evidence that this jurisdiction was actually exercised over the disputed island. And I have to mention the case of UK versus France. In this case, UK was able to prove historic title by showing that the court in the UK exercised jurisdiction over a case involving wreckage, which took place on the disputed island of Mingas and Icreas. Okay? Here, in Malaysia versus Singapore, the same is true. The Sultanate of Johor was recognized as a central authority by most Western maritime powers, and it was also able to prove that it exercised sovereignty over the islands by showing that it filed diplomatic protests against Dutch activities taking place around the disputed islands of Pedra Branca. Okay? Without those evidence, it would be difficult for one to see any prior existing title based on clear and convincing evidence. And then I tested the consensus against subsequent conduct. This is a document which referred to the note verbal of the US, of China in 1970. It shows here a recognition that the Senkakus fall under Article 3 of the treaty, meaning it is minor islands rather than Category 3 Formosa. This is also the note verbal coming from the ROC, where it says that they're asking for the termination of the occupation of the Senkakus, which means that they know that the Senkakus were under US occupation rather than treated as part of Formosa. Finally, this is a memorandum of the conversation between Kissinger and the Foreign Minister Chow Shukai, right?
Chow En-lai.
No.
Oh, ROC. Okay.
Yeah. At this time, the ROC was protesting the negotiations between the ongoing negotiations between Japan and the US for reversion of the islands. Chow and Kissinger had a meeting where Kissinger pointedly asked ROC, you don't want the islands back. You just want to avoid a big fuss. At that time, the discussion was around neutralizing Senkakus rather than awarding title to either Japan or the ROC. And the response of the ROC was, yes, that's right. So if you look at the entire conversation, you will see a recognition that they were not claiming the islands anymore. They just wanted it to be considered neutral. Right? So I come to the 6-point conclusion that first, the use of status quo post bellum is a viable tool for addressing the dispute. Number 2, the islands belong to category 2 rather than 3 for MOSA. Number 3, there was consensus that the islands remained under Japan's residual interest. And 4, that Japan was the sole claimant at the end of the war. And the consensus does not contravene any prior legal title, but instead it is confirmed by subsequent conduct. Thank you very much.
Thank you very much. We have time for questions. Would anyone like to start? Well, perhaps I'll start. Oh, Professor Davis will start.
Yeah. I would just, because I wanted to comment, this is really fantastic. I've read most of the literature on these islands, because I wrote an article myself, and on this dispute. And a lot of people reach the same conclusion you do, more or less. It tends to favor Japan, unless it's a Chinese writer. It typically favors Japan, scholarly writings on it. But I don't think anyone has gone through the documents so carefully. I see bits and pieces of these documents and the other writings, but not this full package. So I think your article will be very useful. Unfortunately, of course, China will have none of it, and will not likely submit this dispute to an international tribunal. I haven't seen your articles. I don't know. Do you go on further to talk about any kind of path to resolution of the dispute? I think many of the other articles tend to do that. Perhaps you chose not to, but I just thought I would ask and see if you had any suggestions. 1, and 2, do you see any relevance of this to the disputes in the South China Sea?
Thank you very much, sir. Very interesting questions. I did not explicitly propose a way for resolving the dispute. I merely suggested the use of primary documents to clarify the situation. Most of the authors I read referred to each other, so mostly they're secondary sources. So there's need for archival research, and HKU has a lot of archives. The South China Sea dispute is one dispute where status quo post bellum would certainly apply. The use of that alternative approach would whittle down the parties to 2, Vietnam and China. The Philippines will be definitely excluded. It would also set the critical date at 1939. Yeah, between 1939 and 1942. And certainly it will exclude the Philippines as well. So yes, certainly.
So you're saying no islands in the South China Sea, or just some of them would exclude the Philippines?
I have written also another article which will come out in UDIL, and it's called Spati Islands as a Single Unit. And I found that Spati Islands was understood in the peace treaties, in the 2 peace treaties, to mean Sinan Gunto. And it's a defined space. And none of the islands there was being claimed by US, the colonial power at that time, or the Philippines. And therefore, if that was the understanding during the peace treaty negotiation, then certainly the Philippines would be excluded. In fact, there were studies by the State Department on the possible claimants to the islands. And one of the studies mentioned the Philippines as the possible administrator of the islands. In the subsequent document from the Territorial Subcommittee of the State Department, the conclusion was that it would be unjust to China and Japan for the Philippines to be considered as a claimant, considering that there was no prior claims to the islands by either the US colonial government or the Philippine Islands, Philippine government at all. So yes, this approach would certainly apply to the South China Sea.
Other questions? Yes, Janice.
As somebody who knows absolutely nothing about this, this was very fascinating. Thank you very much. Two things. In terms of a way forward, and not at all a criticism of your analysis, you note at the beginning that China was deliberately excluded from the treaty negotiations. It seems to me that there is a distinct problem here. The approach that was taken towards these islands had a lot to do with the fact that the government that was recognized as the government of China was Chiang Kai-shek and company, and not Mao Zedong and company, and that political decision may very well have determined the way in which these things went. We do not know whether the other contender for the control of China, and arguably the ultimate victor, would have taken the same approach, and whether, in fact, I mean, one of your documents says that temporary military conquest doesn't count, can't change the end result. So although you start at 1945 and look at Japanese sort of claims and occupations, it might not be unreasonable for the Chinese government to take a longer term and rather different view. What do you think?
Yes, I agree. If we pursue the question along the lines of the peace treaty, certainly we will have difficulty convincing China of any validity or any resolution along that line. But if we look at the Eritrea case, Yemen was considered a non-signatory to the peace treaty, and the fact that it did not sign the peace treaty did not prevent the court from applying the treaty to the disputed islands. And we have to remember that in this case, the Yemen case would not apply, totally apply, in the sense that we have here a document which says, the Cairo Declaration, which says that all the parties, including China, must decide. So this document itself says that even if China had no direct interest in that island, it must be part of the entity which would decide the fate of the islands. Okay, this is one of the difficulties I had with this research, and one where the reviewer focused on, and is saying that you have the Cairo Declaration where it accepted China as a possible party to any resolution of the disputes. Yet, eventually China was excluded. And how do you address that particular question? All right. To address that question, I looked at the conduct of the parties. In the 1945 period, you have conduct coming from the US, Japan, and other allied powers, determining the fate of the minor islands as being under the administration of the US, subject to subsequent return to Japan, without any conduct coming from China objecting to it, to that kind of view. In fact, I found conduct of ROC in particular endorsing that view. Therefore, even if you have a Cairo Declaration which required all the parties, China included, to decide the fate of the islands, yet China was not included in the peace treaty, yet you have conduct saying that China accepted the decision of the Allied powers to place the islands under Category 2 and eventually return to Japan. So that's how I addressed them.
But it is only Chiang Kai-shek's China.
In 1945, Chou Enlai accepted that in 1945, China's ROC was the government in power. So the signature of
Chou Enlai?
yeah, I cited it in my paper, but I didn't put it here.
Yes.
Han Kim, thank you for the presentation. It's quite fascinating. May I ask you to go back to the slide about the defining the concept of the status quo post?
Sorry.
The slide defining status quo and
Alright.
a post-bellum.
I have some one conceptual question and second practical question. So the first, it talks about the the third the part. It says it becomes effective after like silently recognized. But being silent doesn't necessarily mean consent of the parties.
Yeah.
So I'm just curious, conceptually, why would you like define or draw the line from that time? Because when it's not sure that the parties doesn't really express or implicitly imply that they consent to the agreement, how can you be so sure that it's the kind of starting point of the this issue? And the second, the last part of the sentence is the basis of the future relations. So being silent at the moment doesn't necessarily guarantee the silence in the future, right? It can be revoked, or people can raise the issue eventually, like after 10 years or 20 years. So it's not. I'm not sure how conceptually is like reliable. And so the second question is as a continuation of the first question. How legally binding is it, the treaty, when there's no express consent, and when it's not sure that there's no mechanism that can guarantee the prevention of such revocation? What's the meaning of the practical sense? There's no legally binding mechanism. So I'm curious how practically is it effective?
You're saying how legally binding is the treaty amongst parties, amongst countries that are not parties, that have simply remained silent? Is that your question?
No, when there is no consent, because we are not sure.
I'm just clarifying your question.
Yes.
If your question is how legally binding is a treaty, the treaty is legally binding between the parties to it. But your question is how legally binding is the treaty in relation to parties, countries that are not party to the treaty, that have simply not objected, have
Yes,
simply
that's
done
my
nothing,
question.
have simply remained silent.
Yes,
That's
exactly.
your question.
Yes, that's my question.
Thank you.
First question is the use of tacit recognition as the source of territorial rights. We recall that title has 4 elements: defined space, facts, evidence, and then the law. And in international law, the law would be the set of rules agreed upon, but it could also be the rules which are conceded to by the states. And consensus could be express or silent. Okay? So under international law, tacit recognition can be a source of rights. This is especially true when we are talking about customary rules of law. Okay? Then you say that how can you be sure that that silence will be maintained in the future? What if there will be an objection? Exactly. There has to be an objection to the prevailing situation. And I found no objection from the period 45, 52, 52 to 70. All right. To address the question of tacit recognition, I looked at the sources such as jurists. They recognize that tacit recognition can be a source of rights simply for the reason that you have no third state or third entity which will decide whether the territorial position of one party is better than the other. the fact that they have ceased to conduct their hostilities and desisted from mutual extermination gives rise to a presumption that they accept the situation at present as a legitimate state of affairs. So that's according to the views of jurists, and also because of the benefit of third states and third parties. Right? I also use state practice. In state practice, especially in the following treaties, incorporation of a status quo clause is apparent, and the fact that they recognize it as their position, to which they shall refer when they have questions about territorial disposition. Okay. And then the use by tribunals. That's how I justified my application of tacit recognition as a source of rights. Okay. Does that answer?
Yeah, but I mean, because
It's not quite clear that you've answered the question. What you've said is that silence can amount to recognition,
of consent.
can amount to consent.
Yeah.
But you've always qualified it as can. You don't say that silence will always equal consent. The implication is that there are some situations, perhaps many situations, in which silence will not imply consent.
Yes.
So that what I think the questioner is asking is, in your analysis, where do you look into the factors that may suggest that silence on the part of China in particular matters, should or should not be regarded as consent? All you say is there was silence, but that's only part of the picture. What is it about that silence that can lead one to say that there is consent? I think Janice Braben's question is effectively, if you're fighting a revolution, if you're trying to bring about order in a large country, then it may not be surprising that you're silent, because you have a lot of other things on your mind between 1943 and 1971. You've got all sorts of other things on your mind. Minor islands, for the moment, are not within your radar because there are lots more pressing questions. And that's why you're silent. That silence should not be read as consent in that particular situation.
Which is why the approach requires testing the consensus or your silence against whether your subsequent conduct confirms the presumption that you accepted the territorial situation. And testing, in the two tests that I applied, I referred to Erica versus Yemen, where the court did not simply accept the tacit recognition of Eritrea's title. It also tested that recognition against any prior title and subsequent conduct. So usually, if you look at their decisions using tacit recognition, they always need to test it against the past and the present, the future. And I showed that when tested against the past, there is no clear and convincing title which would be contravened by the status quo. When tested against the future conduct, there is in fact confirmation that that was the state of affairs at the end of the war.
Perhaps we have time for one more question. Yes.
I'm trying to think about, first of all, I fully appreciate your approach. I think that is fantastic, because nowadays people do not even bother to look at historic record, and that is perfect. But the second one is, I like to continue the argument from this lady and this gentleman. That is, I'm trying to make an analogy to a natural person. For example, especially between Taiwan and China, because the government are now, even today, theoretically and legally, they are in civil war. Would that be fine for us to say that we have two entities, and then it's quite like a mentally incapacitated entity to make a decision about, about especially the territorial dispute, because there are two governments in the state, and continue Professor Ray's argument that it is perhaps not so able to make such a vital decision as to the territory of the state. And my second argument would be if it is possible for us to clarify or to define the extent of the silence or tacit recognition. For example, say a Taiwanese fisherman go to Senkaku or Diaoyu Island for fishing and then come back to Taiwan and the government of Taiwan impose tax on this. Would that be certain level of, say, governmental regulation on this?
Yes.
Or something like
Yes.
that?
Yes.
Okay. Yes. Silence as a source of rights in international is a tricky question all the time. The only way for us to make an ascertainment of it as a source of right is if it's reducing a formal instrument, for instance. But there are other ways as well, as when you test it against subsequent conduct. If there's an incident which would require any reaction from the state having any latent interest in the islands, and that reaction is not forthcoming, certainly a presumption arises that there is no right involved.
If I can clarify my argument, that is, because your argument is based on evidence, on the historic record, and then you look at the peaceful treaty from San Francisco or something like that, and then you find both governments, Taiwanese and Chinese government, are absent in such record. Would we be able to say such historical record or evidence is tainted, or somehow not demonstrating the will of the other party or consent or silence of the other party?
In this case, the records actually are not silent when it comes
because
to
the record, you use such record and subsequent record to prove the state conduct. And then we say the state mind is either disabled or impartial or something even absent in such record. And then that goes to the point, the merit of your argument, the validity and reliability of such historical record.
I don't think we're going to be able to resolve the dispute today. I think from what Melissa has said, a lot depends on what you mean by testing. And different people may have different views as to whether certain acts constitute sufficient testing. Melissa has focused on particular evidence. You would say one should focus on wider evidence. For instance, what about the behavior of Taiwanese fishermen going over to the
I'm talking about
Senkaku
Taiwanese fisher regulation.
This might be evidence of some sort, it may not be. That's a matter for discussion. That's not a matter for discussion today. For today, I think we just signify our appreciation to Melissa for the way in which she has stimulated our thinking about the matter, brought certain issues of public international law to the fore, and illustrated the way we might start to think about things in order to bring about some sort of resolution over long-standing disputes, and we're grateful for that. Thank you very much.